So maybe I start with to reflect on provisional measures in connection with lis pendens. And I start with putting 3 questions. Can this provision on the provisional measures be used by a member state which has jurisdiction on the substance of the case? This was my first question. My second question, when the text of Brussels II bis says that the measures has to be taken in respect of persons, what do we mean with persons? Is that only the child or also the parents? And what about the extraterritorial effect and the territorial limitations? So our academic speakers have already spoken about this situation. We know so that the Court of Justice has said in a Kruger case that a court that has substantive jurisdiction can also be the court using the article, the provision on provisional measures, and that those measures do not qualify for the system of recognition and enforcement, so they have no extraterritorial effect. That is also in this case, and then in the in another case, the Osijek case, there was explicitly the court that said that it could be not only in respect of the child, but also in respect of the parent to whom custody of the child is granted or is deprived. When it all goes on about the fundamental rights of the child in the having a relationship with both parents. So my comment, putting all these questions together, the question was, in a case that I'm going to tell you about, can this provision be used by the court that has jurisdiction on the substance, but that cannot establish its jurisdiction because of a lis pendens situation? So it was a second seized court, and the child was not present in that state. And if yes, what are then the effect of those measures? So the case is the following. We had that in the Court of Appeal. It were Italian parents, and the mother abducted the child to Italy, and she seized an Italian judge on the custody, on divorce, and on parental responsibility, on whole proceedings. And Italy scheduled a hearing a couple of months later, 5 months later, I think. And when the father realized what was going on, he took him a week or two to realize that the mother was not coming back, because both were living in Brussels and were working in Brussels. He seized the Belgian judge, and he also started a return case in Italy. The hearing in Italy on the return case was also scheduled a bit later, a few days before the custody case in Italy. But in the meantime, the case in Belgium was going on. And first idea from the first instance judge was to say we have to stay proceedings because Belgium is second seized. And in any case, the Italian judge could not go further either, even if it had a hearing on the substance because of Article 16 of the Hague Convention of 1980. It had to stay proceedings because of the abduction. So there was both judges in both countries on the substance could not do anything. So we had only this Article 20, the provisional measures, because there was a real urgency. The father had no way to get in touch with his child. The mother was completely disappeared and did not want anything from the father. So this urgency made, okay, the father went then in at the Court of Appeal, and there we saw this urgency, and our court did use this article, considering that the father is in Belgium, not the child, but that, as you know, the article says it can be a person. So we consider that the father being in Belgium could be, we could use this Article 20 without establishing the jurisdiction on the substance. Because of Article 19, we had to stay the proceedings on the substance. And then this court, we took these measures in different options. measures that could be enforced in Belgium if the child comes back. 2 options: if the child comes back with the mother, or if the child comes back without the mother. So we made this both hypotheses, and we ordered an expertise as well. And then also the Court of Appeal in Brussels decided about measures to be enforced in Italy while the child was not coming back yet, so that the father could also see his child in Italy. And the Court of Justice, the Court of Appeal delivered also a certificate to get this enforced in Italy, which probably was an error. Afterwards, I think that because of this non-extraterritorial effect, these decisions could not be enforced in Italy. But anyway, the solution was that having made this good frame, which was lacking during all this time, all this pending proceedings, once the frame was put by the Belgian court, the mother did come back voluntarily. She did not wait for the return order, and she did not wait for an Italian judge to decide on its jurisdiction. So it could deblock the situation. So now with the new regulation, we have this new provision that says that it's only in respect of the child that is present. So I think in this case, the Belgian court would not have be in a position to take this provisional measures. It had to stay proceedings because of second seized. It could not do anything. On the other hand, the good thing would be that that there is now an extraterritorial effect to provisional measures which are taken by the court that has jurisdiction on the substance. This is now explicitly put in this new regulation, so there is both are a good and a bad thing, I would say, in this particular case. And I would say that it's a problem that a court that has jurisdiction on the substance, when it is obliged to stay proceedings, cannot do anything anymore, in a case of abduction at least. And I would say that then the solution would be that absolutely the Hague, the prohibition from the Hague Convention that says that the court where the child of the state of refuge, where the child is, cannot take any decision. This court maybe should not take, of course, any decision on the substance, but should hurry to take the decision on its jurisdiction so that it can deblock the lis pendens situation. So this would be very important, and I think we would have to communicate between judges, amongst judges, to get this better. Another point that I wanted to raise is the situation of provisional measures in Hague return cases, this combination, where, as we've seen, you have already explained that under Brussels II bis, the measures taken by the state of refuge cannot be enforced, but we have this Article 11.4. So if a judge wants to refuse the return, he can ask to the judge of the state of origin to take provisional protective measures. Okay, this maybe was a counterbalance. Now under Brussels IIter, we have this specific provision that says that provisional measures taken, what Ilaria called the third track, this provisional measures taken in order by the return court to protect against the grave risk allegations. These measures will have extraterritorial effect, but we still have the same system as our system of 11.4, which is now Article 27.3 and 4. So we have two courts that have the possibility to take provisional protective measures in a situation of grave risk. And then my question is, which priority will be given to the one or the other? Which will be the first? My first thought would be, okay, the provisional measures taken by the state of refuge, they cease to apply when the state that has substantial jurisdiction takes appropriate measures. That would be logic. But what happens if measures of the state that has jurisdiction are earlier than the measures taken by the Hague Court? So you could say, logically, this is not possible, because if there are measures taken by the state of origin, there is no urgency for the Hague Court to take measures. But still, it may be that the measures taken by the court of origin are not satisfactory, even though they are enforceable. It happens often that when the left behind parent rushes to the court of origin, his court, he asks to deliver a quick judgment, which is often, I don't agree with that, but a lot of judges will do that. They give an ex parte judgment, giving all the rights to this left behind parents. This is a mistake. One shouldn't do that, but that happens. And then there is an appeal against that, or a review, it goes back in a contradictory proceeding. But what is pending this review? What is the return court going to do? He has to enforce a decision. Can he take other provisional measures that will have priority on this ex parte judgment? You see, maybe you think I make it all much too complicated, but in a way, that is the life of judges when the cases are really battling, when parents are really battling to get the final word in the case. So the timing and the logic and the fluency that the legislator thinks that should happen when he thinks about how it happened is not always the case. Some countries are quicker than others, and some judges are quicker. Some lawyers manage to get earlier or to go and have a relief and appeal. So anyway, then I also, there is more. I noticed that there is an article 53.3 in the new regulation that speaks about partial enforcement. And there it is written that it is not possible for a return decision to be enforced, I say it another way, when a return condition is combined with provisional protective measures in the case of grave risk allegations. You cannot enforce partially. You have to enforce everything. But if the court of origin has already taken provisional measures, there should be this, again, this is a problem, I think. Okay, my opinion is that the only way to get out of this kind of mess is that judges can speak with each other and that we can organize the proceedings in a logic way. But this is, we try, it's not always easy. So I wanted to speak to you about the transfer of jurisdiction, but I see that time is going on. Also, about the transfer in connection with lis pendens. Can we use a transfer rule if a lis pendens rule if we are in a lis pendens rule between two courts that do not have jurisdiction at the same moment? I give you an example. A first instance court in Belgium has a debate on the relocation of the child, and he grants the relocation of the child to Poland. And the child is relocated in Poland, and the father is relocated with the mother. The father is not really happy with that, but he says, okay, let's try. Let's see what's going to happen. And he thinks that he will get no contacts anymore, that the mother will try to cut the child from him. So that was his things, but he will give it a chance. And a bit later, there are problems, and the mother seizes a Polish judge. And the father, instead of going and keeping on that proceeding, he is going to appeal the first decision. So by appealing the first decision, he gives artificially a revival to this decision, because it had not been, the delay for in appeal had not been started, so he could do it. And artificially, it overturns it makes the lis pendens case with the Belgian being the first seized. And in that case, the solution has been that we used Article 15 to send the case to say, okay, we are first seized, and we were seized at the moment that the child was still in Belgium, has habitual residence. So we had to establish this jurisdiction, but we send it over to Poland. And so we got out of the case. It was therefore a surprise for me when I saw the case, the decision of the Court of Justice in a case EQ against GP, where the court says that Article 15 cannot be used to transfer between courts that normally have jurisdiction both. So you may remember that case. The proceedings were in Romania and they were pending an appeal, and the jurisdiction was established there on the basis of Article 12, so the agreement of the parents. But the mother started proceedings in the UK, and where the children were habitual residents. And the UK, in first instance, asked for the transfer of the Romanian case. And the Romanian court put a preliminary ruling asking whether it was possible for an appeal court to transfer a case, but the Court of Justice did not answer that question. It said this is not a case for Article 15 because both courts have jurisdiction. So I'm a bit surprised. I don't think this was what I expected, but whatever. Then another situation where where I can speak about transfer connected with provisional measures. That's another case that I heard about in a Belgian judge who wanted to transfer a case to a French judge, because all the parties were in France at that time, even though at the moment of the seizure, the parties were living in Belgium. So he wanted to send it, but there was at that time not yet, not any decision on custody and on access. So there was an urgency to take at least the provisional situation to secure the situation in the family, between the parents and the children. And he did get in contact with the judge in France to know whether he was able to hear the case very soon, very quickly. And depending on that answer, he was considering taking himself provisional measures for the time that was going to be between the decision and the hearing of the court in France. So that was a successful communication, and I think a good thing. Okay, the transfer provision raises on itself a lot of questions, and I think the new regulation, do not answer to all these questions. I'm just going to list them to you, and okay, you tell me whether I have to stop because of the time, but I list you all the questions that I have thought about. Can an appeal judge apply this provision, and to which judge does he have to transfer the case? This is a first question, and as I said, the Court of Justice got this question but did not respond to it. A second question, what is the form of the decision and the communication at every stage of the process? When it is a transfer from a competent court to a non-competent court, you have 3 decisions. You have a decision from the court that is going to stay the proceedings and decide to request the transfer. You have a decision of the court that have to accept or refuse the transfer, and then you have a decision about the decline the jurisdiction if there is exception. So 3 decisions. When it is the non-competent court that requests to the competent court to give him the jurisdiction, under Brussels II bis, we had 5 decisions, because you have this decision to request, the non-competent court requests, then the competent court will have to request, because he has to follow the order of the Article 15, he will have to request at his turn. Then the one who earlier asked have to accept, then the other one has to decline, and then there is the transfer of jurisdiction. I think, no, that's four decisions. And I think it's a good thing because Costanza, you said it was not necessary to have a second provision to organize this transfer in the other way. I think it's a good thing that we have the second provision, because we can reduce it to 2 decisions: the request and the acceptance.
Yeah.
And so the question is, how is the court seized when we do all this in the court-to-court communication? There also, this is a court, I have seen everything on that. Are there contradictory hearings necessary at each step? Do we have to take the parties in a hearing and to ask, or is there something automatic just on the file? Is there appeal possible against one or more of these decisions? And if yes, what is the effect? And then I have another question which I often have met. It's in child protection cases. In cases in a lot of countries, in any case in Belgium, the national law says that when it's a child protection problem, a care problem, we have to go through the voluntary aid proceedings. And it's only when there is no voluntary possibility of protection measures that the case has to be put in court, and that there will be judicial protection. And a judge, a judicial, a care protection judge will never be seized without this previous step of voluntary. So it's a problem I have already met, because these voluntary proceedings are confidential. So we cannot tell to another judge who wants to send the case over, we cannot tell what is going on. And a judge cannot take this case. So we find solutions, but it's never really easy. And we often have to let it down with this Article 15.
So there is room for improvement on that.
Yes. Another question also, these questions, are there situations where this article does not apply? Child abduction cases. Okay, now we have this explicitly in the new regulation, but still I have once used Article 15 after Article 11.6 or 6.8. So the case, child had been abducted to France. France had decided non-return. The case was back in Belgium. And the Belgian judge under Article 11.6 decided to transfer back to France, because in the meantime, there had been really evolutions that made that it was really better that France took the case over.